Good morning, everybody, and welcome to our webinar this morning. What are protected or without prejudice conversations? So before we start, we'd like to introduce ourselves. And for those of you who have joined our previous webinars, I am Victoria Templeton, one of the HR Knowledge Managers here at HR Solutions, and I'm joined today by Sue Watson, Head of Client Services, who will be supporting in our polls and fielding questions throughout the webinar today. We are also joined by a team who will be in the background to help and support with us with any technical issues. And please do let us know if you have any questions as we go through the webinar. Please note that there are many of you on in attendance today, so for obvious reasons we've put you all on mute. But that said, we do want to hear your questions, and we'll be taking those towards the end of the webinar. So please do start noting your comments in the comments box as we go through. Here is a quick guide to show you how to do that. You can ask the questions via the GoToWebinar panel, which should look something like this. And please type your question in the question pane, and we'll aim to read out as many as we can at the end of the session. We want to make this session as interactive as we would normally at any of our physical events, so we'll be running a series of polls throughout the session. When we have a poll, it will appear on your screen and you just select the answer that's appropriate for you. But please note that to be able to participate in the polls, you'll just need to ensure that your screen is not in the full screen mode. And without further ado, I'm now going to start the webinar, all to do with protected and without prejudice conversations. So before I get started, I do want to just run through what we're going to cover off today. So first of all, I'll just provide some context in regards to ending employment via settlement agreement, before I then move on to discuss both without prejudice and protected conversations. I'll then briefly share my thoughts on why they are used, before then taking you through several scenarios to illustrate which conversation you'd look to use and when. And at the end of the webinar today, we'll run through some further sources of support that will be helpful to you, and then we'll finish off with some questions that you may have from today's webinar. But before we get going, I do want to just run a quick poll. So if I could ask Sue to call that up on the screen. And it's really just to gauge from everybody that's attending today, whether you've held a conversation before with an employee, and whether that's been a without prejudice conversation, a protected conversation, you've held both types of conversation, or actually you're not actually sure if it was a without prejudice or a protected conversation.
Okay, that one's running now.
Thank you. Let's just see.
Yeah.
Okay.
Okay, I'll close that poll.
Brilliant.
And share the results.
Oh, okay. So that's interesting. So actually, nearly half of you have held conversations, but you haven't actually been sure if they were without prejudice or the protected conversation. Okay, and then so everybody on this call has done something but not sure, or are sure. Okay, that's interesting.
Okay, I'll hide that.
Thank you.
Okay, over to you.
Thank you very much. So looking at today's topic, we're going to talk about just one of the ways in which the employment contract can come to an end in a legally compliant way. So as you can see from the illustration, you've got the usual 5 fair reasons for the employer being able to end the contract. You then have a resignation that could be triggered obviously by the employee themselves. And finally, the use of a settlement agreement, which can be triggered either by the employer or the employee. Although I would say in the majority of cases, it's most likely to be the employer that triggers off the settlement agreement piece. But to end employment via settlement agreement, you must have held either a without prejudice or protected conversation. And there are also certain requirements in which you can hold these types of conversations, which we're going to come on to explore in today's webinar. But if we first consider what is a settlement agreement, so it is a legally binding document. It's essentially setting out agreed terms in which to exit an employee in exchange for the employer waiving their rights to take the matter to a tribunal. It is a tool that can be used for unfair dismissal claims, settling workplace disputes, but also settling issues not resulting in the termination of employment. You know, I don't know, there might be something to do with, you know, holiday approval and entitlements. But there are, it's a tool that's obviously available to employers. And there are two ways in which it can be agreed, and that is either through your protected conversation or the without prejudice conversation, which is what we're now going to explore. So I'm going to begin with looking at the without prejudice conversation and understanding what we mean by this. Well, for those of you who may remember, it was the without prejudice conversation that led to what we previously knew as the compromise agreements. So it's a mechanism in which the communications from it are protected by without prejudice privilege, which means they are inadmissible in court and they cannot be made the subject of a disclosure order in proceedings. Now, in order to be able to have a without prejudice conversation, there does need to be a dispute in place, and the conversation must be held for the genuine purpose of attempting to resolve that dispute and seek that compromise, i.e. to settle, and hence the old name compromise agreement. So essentially this form of communication encourages both parties to speak freely and without fear because it's not admissible. And the type of conversation, it doesn't have any limitations associated to it. So it can cover in respect of claims of discrimination, automatic unfair dismissal, your breach of contract and lawful detriment, and health and safety matters as well. And just to point out that it doesn't deal with or doesn't protect against GP claims. Now, when you now look at protected conversations, these are also known as pre-termination agreements. They came into force more recently as a result of the coalition government way back in 2013. And what they did was introduced a new section to the Employment Rights Act, and that is what you call your section 111A, sorry. And it was introduced because previously to this you had to have shown there was a dispute and an implied threat of legal proceedings before any conversation could be protected. And so the idea about bringing this in place was to address that gap of where there was no dispute. And so the existence and content of protected conversations are not disclosed in an employment tribunal, and there does not need to be any dispute in order for an employer to have the conversation, although agreement must be sought from the employee if you're going to enter into that conversation. And with this type of conversation, there are limitations for when you can get protection from it. So with section 111A to be enforceable, then the limitations that exist for a protected conversation means that there's a narrow definition of it. And so it is restricted to the straightforward dismissal and ordinary unfair dismissal cases. And what I mean by the ordinary unfair, that's where you typically have to have your 2 years qualifying service to bring a claim. Now, if the conversation goes outside of that narrow definition, then the conversation is no longer protected, and it means that that can then be admitted as evidence in an employment tribunal. So these conversations can be initiated by the employer or the employee, and as I said at the outset, it's probably most likely to be the employer that triggers this process. And another important aspect of it is that there is also a legal requirement, and there's case law as well that supports this, that the conversation cannot be improper. And I'll come on now to explain what we mean by that. So improper behaviour can lead to the protection from that conversation being lost. But what does improper behaviour mean? Well, unfortunately, the definition of improper can only be determined by the tribunal, looking at the circumstances of the case. You know, we do have case rulings that can provide that guidance, but essentially it will be looking at the matter at a tribunal and they determining whether the behaviour carried out has been improper or not. But some examples just to illustrate. For example, the employer putting undue pressure on the employee to consider any settlement can be seen as improper behaviour. If an employee is told to enter into a settlement agreement or be dismissed, so given that ultimatum, that can be improper, or that is improper behaviour. And then all forms of harassment, bullying and intimidation. So it's really important when entering into that protected conversation that you don't go outside of the remit, first of all, you know, and that it is used for your ordinary unfair dismissal kind of issues, and that the way in which it's handled needs to ensure that it is proper and genuine. So I'm going to come on to look at why they use. So for some organisations, finding a cost-effective way out of any situation may be preferred, and a settlement agreement can be used to achieve this. So I thought what I would do is, on this slide here, is actually show you the tribunal awards that have been made in respect of discrimination claims from 2019 to 20. Now these are just your discrimination claims alone. They don't allow for any other awards such as those associated to your unfair constructive dismissal, loss of earnings, or even the costly legal fees for putting together your defence and any management time used for providing witness statements or even attending that tribunal. So I just thought it would be useful to highlight that the connection between why there might be a commercial argument as to why an employer might want to consider those conversations. Now, it is tempting to look at the maximum awards here, and the high awards for the cases involving, in particular, your disability and age discrimination are particularly eye-watering, but it's actually more useful to look at the average column here. But even so, they're still significantly high. So, as I say, this is why for many it can be a commercial tool for resolving the matter as cheaply as possible. But there are other reasons too, apart from being a cost-effective way to end the employment relationship. They can actually be a way to shortcut a process, which is beneficial for the organisation, especially when it comes to, for example, performance management, you know, issues which can take many, many months to resolve. They can actually be more appropriate, a less stressful way for the employee to exit the business instead of going through a formal process. You know, and some employers are very mindful about how an employee being going through a process, what it might, how it might affect them. So actually, it may be chosen for that reason. And of course, they provide protection from future employment tribunal claims. So there are many benefits to both these conversations. But as I said, as I've gone through, there are very, you need to be clear on which one you're using to make sure that you get that protection for the organisation. So we're going to now look at some scenarios to illustrate when you would use which type of conversation and when. And I thought we would do it in a different way and mix it up with using our polls that we like to typically use. And so what I'm going to propose is that I'm going to put up on the screen a scenario. I'm going to invite Sue to run some polls for us, and if I could ask you to select what your answer would be in response to the scenario, and then we'll share our thoughts after each scenario and explain why which conversation was relevant and why. So this is going to be the first scenario. So I just want to run this through first before Sue brings this up onto the screen. Or have you brought it on the screen? So essentially, sorry Sue.
Put it back, sorry.
It's just because we have to abbreviate the scenario when we enter it into the polls. So the scenario one is around you employ a senior manager who is underperforming, but you don't have the confidence that their performance is going to improve. And rather than having a lengthy drawn out process, which could become challenging and cause tensions in the relationship, you decide to hold and is your answer going to be a without prejudice conversation, or is it going to be a protected conversation? So Sue,
I hope I haven't broken it. I've got a horrible feeling I might have broken it.
We'll give it a go, and if not, we'll talk through.
Yeah. Just yeah, I'm really sorry. I think for this one we're just going to have to talk through. It's not letting me.
Shall I have a go at launching it? See if that.
Yeah.
Hang on.
There you go.
There we go.
Well done.
I don't normally get the technical side of things right on here, but so anyway, it's worked. So what do you think? Do you think in this scenario where you have a senior manager underperforming, you don't have the confidence that you'll be seeing improvements, so rather than that lengthy drawn out process, which could be challenging all round for both parties and perhaps cause tension, then would you enter a without prejudice conversation or a protected conversation?
I think it's actually showing the results.
Oh.
Not the I think it is. Yeah.
Okay.
Okay.
So on this one, I think we'll just talk through it, Sue.
Yeah.
And hopefully it will work for the others. So in this scenario, you would be better to have a protected conversation. It's going to be a quicker alternative to going through a formal drawn out process. Performance management in particular, as you probably know, is very lengthy and can take many months to conclude, especially when you're dealing, at senior level, when perhaps, it's being able to see the turnaround of the performance improvements might take longer, just given the nature of the role they do. And so other considerations in this situation is, you're probably thinking about, you're preempting the possible impact on the continued relationship whilst going through performance management. So your protected conversation is the route to go down, but you still need to be a bit careful about how you open up the conversation. And I would say the safest way would be to already be in some kind of process, or at least have the opening meeting with them and lay out the concerns. But essentially, you'd go down the avenue of a protected conversation. Would you agree, Sue? Is there anything else that you would add on that particular scenario?
I think, yes, I agree totally. And it's also commonly used with a senior manager maybe to help them sort of leave under an agreement, in a good way. And also sometimes people who are sort of close to the other end of their working life, they're maybe at retirement, what was the traditional retirement age, and to enable them to go with dignity, if it's because they're just have lost their sort of enthusiasm for the role, and it enables you to let them go in a nice and a kind way, which is commonly how they're used. But it is much safer to be in a process, or at least have started it, not putting any threats, just say, look, these are our concerns. However, in view of whatever, we would like to discuss with you an alternative. Would you be prepared to have a discussion with us and around this, and you continue that way? And that means that if you can't reach any agreement, if the expectations of the employee are far beyond what you could ever hope to settle for, or you just can't reach agreement, then the alternative then is you go back into the process. Whereas if you just launched that conversation with them and started talking about them departing from the company, and they don't agree with what you're offering them, then you've already made it clear you no longer want them in the organisation, and you could leave yourself open to a constructive unfair dismissal claim if they've got the sufficient service. So it's a way of protecting you, but also being fair on the employee, making it clear what the issues at stake are and why you're looking to have this conversation.
Yeah, brilliant. Thank you, Sue. So I'm going to attempt to use scenario 2.
Yeah, I won't click until you've finished.
So scenario 2, we have here that a discussion needs to take place with an employee who's been on long-term sick for around 10 months. The business has genuine concerns they actually won't be able to return to work. So you decide to enter. Now, is it a without prejudice conversation or a protected conversation?
Okay,
And
here we go.
do you want to open the poll? Yeah. Looking good so far?
Yep, it works.
So a couple of more moments. Do you want me to close it or a little bit longer?
Okay, close. Yep, and I'll share the results with you. Oh,
So,
split almost.
yeah, 55% would have a without prejudice conversation and 45% would have a protected conversation. So this scenario would actually need a without prejudice conversation. And if we think about those types of conversations, don't have the limitations, and so they're typically used where you've got potential discrimination claims. And from this scenario, the potential discrimination element is the ill health, which could be potentially a disability under the Equality Act. So where you've got potential discriminatory elements, factors, which, you know, age, race, religion, sex, you know, etc., then you are safer from a protection point of view to enter that without prejudice conversation. Is there anything you would like to add, Sue, on that?
No, I don't think so.
Right.
I think that's clear. Just to clarify an earlier point, we had a question come through that
Yeah.
you do need to make it clear which type of conversation you're about to have. But when you initially invite someone to a meeting to discuss their performance or whatever, or in this case, their sickness, you might not at that point be entering into a conversation and they may not agree to it. But at the point where you decide to adjourn it to have a without prejudice or a protected conversation, depending on the scenario, then you would need to make it clear that is what you are offering them the opportunity to do. But you do have to be clear which type of conversation it is you're having, because they attract different different protections, and obviously some of them have different options around them and how to handle them.
Yeah.
Okay.
Thank you.
Okay, I'll hide that one.
Lovely. And I'll move on to scenario 3. So we have a female employee who has raised a grievance about how they've been treated compared to a male colleague and is refusing to return to work after having also a period of stress-related absence. Now, she is asked to leave employment under a settlement agreement. You accept her request and hold, now is it a without prejudice or protected conversation?
Let's watch that one. And that's that concluded now. Let's close that one and share the results.
Okay, so 73% without prejudice and 27 protected. Okay, and 73% of you would be right on this one. And again, from the scenario, you can see that there's potential discrimination elements, and in this case, sex. Now, obviously there's talk about ill health, stress related, and stress is one of those that it could be a symptom of, you know, anxiety, depression, etc. Part of that, and it doesn't necessarily mean it's automatically disability under the Equality Act. But on this, I'm thinking it's more around the gender side of it, the sex discrimination. And the thing I would probably say on here is, even though the employee has asked and wants to leave, you would still want to secure the exit under a settlement agreement and have that without prejudice conversation. Because if you were to just accept that resignation, you're still open up to claims of constructive dismissal claims. So, you know, it might think, oh, they're offering to, you know, they're resigning, they're wanting to go, you know, but actually don't get caught up in that trap, because there's risks attached from a constructive dismissal claim. So yes, you would want to secure that exit, but through a without prejudice conversation.
And I think I'd just add to that, where grievances, there's not necessarily a dispute. So you have to be a little bit careful when using without prejudice with grievances. It's often when the employee is threatening tribunal, they've gone to ACAS already because they're in the middle of the grievance and they don't feel it's being held appropriately. Most commonly when you've issued the results or the outcome and they have appealed, maybe they're not happy with the outcome, and also so they cannot go back to work in the circumstances that they've raised the issues around. So so that then there would be a dispute because the employer is believing there is no grievance or it's been resolved, and the employee doesn't, so and cannot accept the employer's decision. So it is sometimes, but grievances are there to try and help you resolve issues in the workplace. So very commonly they are resolved, and hopefully, you know, and that is the purpose of them. So it is quite case specific as well, and it is making sure that there is a dispute there. So it's a disagreement, or there's litigation being threatened, or got a high chance of a case being brought against the employer. So yeah.
Thank you.
Okay.
Yep, brilliant. So we've got another scenario.
Yeah.
Okay. And this scenario is about employing a sales manager. They've got 4 years service. With the pandemic, it's meant that you've had to restructure the business and fundamentally change that role. Now, this scenario is about wanting to avoid an upsetting process, you know, and you want the matter to be dealt with as quickly as possible for the employee, to save them going through any lengthy and stressful process that is attached to obviously being made redundant. So here you have the option to withhold a without prejudice conversation or to have a protected conversation. So which one would you choose?
Let's launch that one. Okay, let's close that one off.
Yeah.
And share the results.
Ah, okay. So 92% of you say protected conversation and 8% without prejudice. And with this one, it's the protected conversation. So 92% of you would be right. Now, this is another situation, you see, where it is a straightforward dismissal. You're looking for a quicker way in which to manage a situation. And as I've spoken to earlier in the webinar, you know, sometimes a settlement route can be less stressful for the sorry, that didn't make sense, can be less stressful for your employee. And so some organisations, as I say, prefer to take that kind of approach. So yes, it would be a protected conversation that's appropriate in those circumstances.
Okay, let's hide that one. Over to you.
Thank you. And scenario 5, which I think is penultimate. So your employee raises a question of whether a settlement is possible during their disciplinary process. Which one would you choose from a conversation point of view?
Okay, I'll close and share those.
Okay, more evenly balanced. So we have 57% without prejudice and 43% protected conversation, and it is a protected conversation that you would enter into this scenario, because here we're looking at shortening the process, and that process has the potential for dismissal. And if we remember, protected conversations are limited to your ordinary unfair dismissal claims, i.e. those that have got your 2-year service or more, not the automatic unfair dismissals. So yes, that would be a scenario for that type of conversation.
Okay.
And over to our last poll. So let's, not poll, scenario. So scenario 6 is around you're wanting to terminate the employment contract, but there is not sufficient reason for a fair dismissal. So do you hold a without prejudice or protected conversation?
I think that was dividing the audience, this one. Okay, let's close that and share the results.
Okay. So 54% protected and 46, very, very close, isn't it? And here. So with this one, it is a protected conversation, and if we think about, again, it's dealing with a potentially exit that there's no real reason for that fair dismissal, and so that's why you'd go down that protected conversation, to give yourself protection from any unfair dismissal claims and awards.
Yeah, I guess there could be some context in which a without prejudice might be possible if maybe the employee's gone straight to ACAS, which recently we've had a few experiences of through the helpline. Employees have, instead of bothering their employer, they've gone straight to ACAS, and in that way, that would be in dispute because they've gone to potentially threatening litigation. So I guess, it depends on the context sometimes.
Yeah. Brilliant. Okay, thank you. So I'm going to, so the poll's close. So with that, then, I just want to conclude and just summarise, and I thought a table is quite a good visual, and you will get copies of the slides, by the way, after the webinar. So this just separates out the two types of conversations and just summarises what you need, what you don't need. So as you know, the without prejudice, you need to have that dispute, and there needs to be that genuine purpose of attempting to seek your compromise. But there are no limitations, so that's where it can cover your discrimination, health and safety issues, automatic unfair dismissal, i.e. no qualifying service, and breach of contract. Whereas your protected conversations are restricted and limited to your ordinary unfair dismissal claims, and you do need that agreement from the employee before entering into it. And don't forget, they can't be improper. So yes, that's a useful table just to separate, distinguish between the two. And just before we close and see if there's any further questions from everybody, I just want to just remind you, if you are a knowledge base member, then there is access to a template settlement agreement on our knowledge base, along with a cover letter. And there is also plenty of articles that we have in regards to ending employment, not just in terms of through these types of conversations. And of course, what's also important is that when entering settlement, going down the mechanism of a settlement agreement, that you are adhering to the ACAS Code of Practice, which I've provided a link here for you as well that will be available when you get the slides. So I'm going to see if we've had any questions then, Sue, on the back of that, or have our scenarios kind of answered questions?
I covered most of them in the in the actual answers. There's one question about, does the agreement to enter a protected conversation need to be in writing? No, it doesn't need to be in writing, does it? It can be a verbal agreement to enter the. You would only put in writing a draft proposed agreement initially and so you would resolve it in writing, but you would start the initial conversations would be you would make it clear we are entering into, and you would probably lay out what that meant, at the beginning of the conversation. And I think somebody's also asked about, do we need to minute the conversations? I would definitely minute if you were starting it from the point of view of a process such as a performance management or a disciplinary. If you were starting one of those processes, you would be minuting those as you would normally. But if you adjourn for an off-the-record conversation, then it can be off the record. But you'd need to make notes about what is being said and agreed, so that you can build that into the agreement. So it's not so much as minutes, because you wouldn't be able to use them anywhere. It's just notes so that you know what you're building in.
From a practical side, isn't it?
From a practical perspective, and I do totally agree that context is everything in this. So some of the scenarios we've given have been without context, really, just to try and show that there is a difference between the two and the types of situations where you might be exploring one or the other, but some context may mean that it actually goes one way rather than the other, because a dispute might suddenly appear when it hadn't before. So yeah, there's you do have to be careful.
Definitely.
And there's quite a lot of queries around how you start the conversation, and that's kind of is the tricky bit. So if you're I guess for either conversation, you are making it clear that you want to have an off-the-record conversation, or if it's a protected section 11A1, or if it's the without prejudice conversation, you make it clear that you want to enter, or would the other party like to enter into a without prejudice or a protected conversation to discuss these issues informally with an attempt to try and reach some agreement. But they are agreements to terminate the employment, so you do need to make it clear what the purpose of them is, and how you're going to conduct it. And there are some kind of rules around conducting those conversations, yes. But yeah, you do. They do need to be careful. If you state, somebody said, what if you state the wrong type of conversation with the employee, and what's the implication? The implication is mainly if it goes to tribunal and they demand disclosure of the documents, because it will lose the protection if you've done the wrong one. So if you've said it's a without prejudice and it's not, then you won't have the protection of the without prejudice, so the documents could be disclosed. So that's kind of the risk of having it, which is also, part of the challenge of them.
It is, and it's a fine balance, isn't it? Because you could also be presenting a really a very sufficient settlement in terms of financial settlement, and actually the reality is, that's going to be enough anyway for them to sign it. I mean, it's risky, but because you don't know if they are going to sign it, but it's difficult to gauge. But yeah, that's essentially the risk. It becomes an unprotected conversation.
Yeah, absolutely. So yeah, that's all the questions, I think.
Okay, brilliant. Okay, thank you everybody for those questions and participating in the polls. So we have one final poll actually that I'd just like to run with you all if you'd like to answer, but we're keen to find out if you'd like us to follow up with you after today's webinar about any of the services that we offer. So we're going to just call up the poll and just ask you if you'd like to find out about our HR services, training, the knowledge base, any health and safety services and payroll. So Sue, are you able to?
Yeah, it's launched. Yeah,
launched. Brilliant.
Yeah, just letting that run. I think we're nearly there. Just a few more coming in now. Okay, I'll close that now.
Lovely.
There you go.
Thank you. Thank you, everybody, for answering that poll. And before we close, just want to let you know of some training courses that we're offering between now all the way through to December. So there's some HR courses here, so ranging from communication skills, disciplinary grievance. Please note that the disciplinary grievance and the equality, inclusion, diversity training actually count towards your CPD. So we're now accredited under the Continuing Professional Development Scheme. And then we also are running lots of training courses from a health and safety perspective, again running between September all the way through to October. Now these ones will be in person at the Kettering Park Hotel, run in a COVID secure way, but essentially because they're health and safety and you need that practical application of the training, then you know that's why they need to be in person, but all the measures will be taken to keep it COVID secure. And then we have launched an updated webinar program, so added to everything to take us up to December. So our next one next month is about how do you manage performance when you are dealing with remote working. So sign up for that if that's something that's interesting to you, but we also have one to do with flexible and hybrid working and the business rationale for introducing it. And then as we get into the autumn, we're moving on to topics that are more your typical HR, moving probably away from the COVID related ones. So you're family friendly, and giving you an insight into all the family friendly options that we now have, managing the menopause in the workplace and looking at how recruitment has changed. Because obviously recruitment now is significantly different, isn't it, to pre-pandemic. And we are also wanting your feedback, because it's always important for us to receive that, and we want to continue to improve our HR knowledge base, and would really appreciate your feedback on how we're doing with that. So there is a link here for you to complete an online survey. It should take less than 10 minutes, but we would really appreciate you taking a little bit of time just to help answer that for us, so we can look at continuing to improve that for you. And if you'd like to stay in the loop and be amongst the first to be invited to our webinars and receive our latest news, then you can also sign up to our newsletter via this link on this slide here. And that does conclude our webinar today. So if you do have any further questions, here are our contact details, our phone line and emails, and obviously website. And your feedback does matter to us, and there will be a brief survey afterwards anyway from the GoToWebinar, just to get your feedback on today's webinar. That again, I would really appreciate taking some time to answer that. And that just brings me to a close, and to just thank everybody for taking the time out of your busy schedule and for joining us today. We hope you can come to all our future webinars, and also I'd like to thank Sue and the team for supporting in the running of today's webinar. So thank you everybody, and have a good day.
Thank you too. Thanks, Victoria.
Thank you.